Thank you, Mr. Chair. Mr. Goldfoot, according to the Bureau of Justice Statistics, DOJ filed only 6 new trade secret theft cases in 2022, as compared with over 91 cases filed between 2017 and 2021. What are your thoughts on why that happened? Why such a reduction?
Thank you for the question. So I think when I look at trade secret case statistics, I'm a little less concerned about fluctuations from year to year. I focus more on the impact of what we are doing and how we're using our resources to best serve the American people. What I mean by that is trade secret cases are truly some of the most complex cases that I've seen worked on in the sections I supervise. These are cases that, in addition to the difficulties that come with being a white-collar case, typically also require the investigators and the prosecutors to become deeply familiar with the technology at issue. And sometimes that means mastery over not just the technology, but an entire industry that you've never heard of or worked on before. I think about a recent case we did involving the chemical lining on the inside of beverage containers, known as BPA-free, and that was a trade secret that was stolen. The work involved in identifying that and preparing a case like that, not to mention the different proof issues involved with the trade secret statute, such as establishing all the aspects of a trade secret are maintained, the amount of preparation can be intense. Now, I think where you and I agree is the number is lower than it ought to be. I wish that we could be doing more of these cases. We're doing what we can with the resources that have been provided.
So, coincidentally, in February of 2022, when DOJ ended the China initiative, do you think there's any relationship there because of the decline in prosecutions? Maybe because of the trade secret theft, do you think this decline had anything to do with the elimination of the China initiative?
Well, thank you for the question. I do not think the fluctuation in the statistics was caused by the end of the China initiative. So the China initiative was, I should clarify, this was my colleagues in the National Security Division. I don't want to take credit for their work, but they're continuing to do excellent work in this field. In February 22, as you say, the Assistant Attorney General Olson, at the same time that he canceled the China initiative, he launched a new initiative, the National Strategy to Counter Nation-State Threats. And this same work as before, looking about China, the PRC's theft of American intellectual property, continues to be done under that present initiative, and now also through the Destructive Technology Strike Force, which has been in effect for about a year. You can look at recent announcements out of National Security Division. In March 2024, they announced one case about an arrest of an individual who is taking technology related to electric car batteries and planning to give that to a PRC-related company. There was another case in March 2024 where someone attempted to steal files from Google related to artificial intelligence technology and give it to a PRC-related entity. So I see the NSD's work in countering intellectual property theft to benefit the PRC continuing. What Assistant General Olson said when he canceled the China initiative is he was concerned that the name was giving people an incorrect impression that the department was cutting corners in these cases. And he found that to be harmful to his prosecutor's work.
Thank you. I'm going to sneak in one more question here. I'm concerned with the amount of counterfeit goods coming into the United States under de minimis, which we talked about before. But Mr. Lord, how are they leveraging the National Intellectual Property Rights Coordination Center when it comes to specifically vaping products, which has suddenly risen, I think, in overall concern about some of the knockoffs, I think, that you're seeing globally right now. Can you talk about that very specific subject?
Happy to, Congressman, and thank you for the question. Our approach to vaping products in the de minimis space is very similar to what we do with other products. So anytime our officers at a port of entry make an interdiction or detain a good, they do two things. First, they call the partner government agency that might regulate that product. In the case of vaping products, that's the Food and Drug Administration, to get some advice on what to do, what should the ultimate disposition of that product be. And then, of course, we have our special agents from Homeland Security Investigations at all of our ports of entry where these goods are coming in, and they'll alert HSI if we, in fact, do make a seizure of those goods. That work that starts at that port of entry then moves up to the National IPR Center as appropriate, based on, sometimes most of the time, it's a pattern of seizures, right, that might speak to certain means, methods, and tactics that warrant a more specific, criminal investigation or additional action by the other government agencies that are at the IPR Center.
Yeah,